Hi, I'm Megan Dabney here with Denise Holba and Liz Holmes, a special needs attorney. We're very happy to have her with us today. And we're just going to ask you some questions if you're all right with that.
Absolutely.
So how long have you been an attorney working with special needs families?
So this May will be 8 years that I've been an attorney, and I've been working with families that have special loved ones with special needs the whole time.
Okay.
Mm-hmm.
You got it, Denise?
Yep. So this interview is mainly about guardianship, but your website says that you do other things also. Can you briefly explain what services you provide with elder law, estate planning, probate work, and special needs estate planning?
Sure. Briefly, asking any attorney to answer a question briefly is kind of funny, but anyway, regardless, I'm an estate planning and elder law attorney. So I help put plans in place. So if something happens to, what if something happens and what now if, something has happened kind of thing. So I draft wills, powers of attorney, special needs trust, both in the what if I die and I want to leave my child with special needs something, but I don't want to render them ineligible for Medicaid setting, since Medicaid is a means tested public benefit and they can only have so much in their name. Or, I've lived through this horrible accident and I have money now, but I can't have money because I'm on public benefits and want to continue being so. And then probate, if somebody dies, what to do next. I help with that. I also help with Medicaid as well. And then I help point people in the right direction for Social Security to get started. I do not handle Social Security appeals at this point, but have a great friend and colleague who does.
Oh, thank you.
Mm-hmm.
So, you kind of covered it, but why is it important to get guardianship of a loved one?
So if we're focusing on loved ones with special needs turning 18, the answer to that question would be at 18, the law says they can be in charge of themselves and everything that they need to do as an adult, which I don't candidly know any 18-year-old who is, but those that have special needs have additional challenges perhaps that might warrant needing a guardianship, which is essentially allowing them to be a child a little longer. Keeping the training wheels on the bike a little longer is another analogy I've started using that I like. But another, totally different, although not completely, might be if you have an older loved one with dementia who isn't able to adult anymore either, similar challenges, different situations perhaps, then that can warrant needing a guardianship. But the thing with guardianship to begin with is the person incapacitated? And while that's not the friendliest of terms, that's the question I ask. So this is not a matter of, mom always speaks for me at the doctor because that's how we've always done it. So therefore, you obviously need a guardianship. That may not be the case. But if the adult with special needs answers with every, yes, and not, every question with a yes and doesn't know why they're saying yes, and can't be coached yet, because guardianship doesn't have to last forever, then it can be helpful in that regard too.
Okay.
Does that make sense?
It does.
Okay.
So you mentioned that 18, because that's where individuals legally become an adult. When do you think, because you have been practicing for so long, when do you think parents should start exploring guardianship? Because from stories, it's like, okay, you're in school, you're at the IEP meeting, the 18 is on the way, and all of a sudden you have teachers and the school faculty throwing parents into a panic saying, you've got to get guardianship, you've got to get guardianship. So what does that look like to you in terms of preparing mentally, what you should be thinking to yourself, questions you should be asking before the actual 18th birthday?
Oh, sure. A lot of people panic about all sorts of things these days, be it COVID or life or, any number of things. I think the thing to remember when you are working through this process, yes, it's obviously your child or your loved one. And so it's natural that your emotions are a little higher, is to, if you remain calm, then your loved one with special needs likely will remain calm. And the person you're calling asking for help will likely remain calm. As an aside, and I'm not obviously not going to name any names because confidentiality and things, but there have been a number of people lately calling my office wanting an appointment the same day. And unfortunately it does, or that moment. And unfortunately it doesn't work that way. If it did, I would never get anything done. And I'm sure the two of you can appreciate that with the work that you do. I would say to answer your question directly, I would start thinking about it. It's never too early to start thinking about it. As far as moving forward with whichever direction, I would say 17 and a half probably would be the best option to start. Again, moving forward with the process to at least have a discussion. And I never make an assumption in a meeting, like an initial consultation with a client. I always want to hear from them what their questions and concerns are before we jump to either power of attorney or guardianships.
Right. Thank you.
Mm-hmm.
Is it a huge deal if guardianship is done after someone turns 18? Can it be done after someone turns 18?
So yes, it can be done after somebody turns 18. Is it a huge deal as in, is the process different? No, the process is not different. It's the same. Every adult guardianship starts off with a physician's report indicating what the incapacity is, why we're doing it. And sometimes, and not just because of COVID in general, sometimes that could take some time to get completed because physicians have more than one patient too. And sometimes you give the physician's report to a client and they don't take it to their doctor, so like timely either. So, there's all sorts of moving pieces with regard to that. The complication with after 18 is whether doctors will be difficult, in the interim, like when you've started and then when you achieve it, that's where it could be complicated. But as far as my process goes, it's the same. And I have had clients who've done it well after 18 for all sorts of different situations. And then when I've had that happen, I know in one case specifically, the judge had asked, well, how has it been working, up until now? Like, why are we doing it now? So it can be done. And in my mind, while guardianship is a very big deal in general, the process is not a big deal after 18 either.
Okay. What are the types of guardianship a person can be awarded for their child? Does it have to be total control? Can this be changed later?
So it can always be changed later. First of all, just because you need a guardianship now doesn't mean you'll need a guardianship in 5 years or 10 years or however long. And you might, I'm not saying you won't, but you might not, you never know.
Right.
So that's the first thing. It's harder in my experience to get out of a guardianship than it is to get into one. It is easier to have somebody deemed incapacitated by a physician than it is to have that same physician or a different physician say, oh, wait, now you have capacity.
Right.
So it can be a little more challenging, not to say it can't be done, but it can be a little more challenging to get out of a guardianship. I lost my train of thought there. As far as full guardianship goes, do you need it? It depends. In most of my cases where kids are turning 18, we do not do the full guardianship. And that is because there are two pieces of guardianship that would make a full guardianship. That's person and estate. Person would allow you to make sure the person's in a safe living environment, make healthcare decisions for them, make end of life decisions for them, basically everything to deal with their person but money. Estate deals with the financial side of things. So often somebody who's 18 who has special needs doesn't have a retirement account and life insurance and all of the things that we're told we're supposed to have as adults. But one thing that they do have is SSI, or potentially on the way through Social Security, which is a whole other discussion we could have. But when you apply for a supplemental security income, which just briefly is a monthly stipend used for food and shelter from Social Security, then the parent or loved one who's applying with the person with special needs, more than likely, can be appointed their representative payee. And that's the go-between between Social Security and that person. So often when the only asset is SSI, the court doesn't get involved in what is now $841 a month, as far as requiring accountings and that kind of thing. They generally, because you have to account to Social Security for those funds and how those funds are spent, the court, in my experience, and I've gone all over the state, generally does not require an estate, a guardian of the estate, to be appointed for that, because even if you were appointed as guardian of the estate, Social Security would still have their process that you'd have to go through. So you don't always have to have a full guardianship. It's not always in the best interest of somebody at whatever age to have a guardianship of both types. And we want to make sure, myself as an attorney advising and whoever the loved one is acting on the behalf of the person with special needs, that we're tailoring it to the least restrictive alternative that's appropriate, because guardianship is not always appropriate, even if your loved one has special needs.
Right, right.
What is the difference between guardianship and power of attorney? And I kind of want to throw in like conservatorship in there too, since like,
Sure.
that's been a thing lately.
Yeah. So conservatorship sounds fancy, but it's just a guardian. That's what
Okay.
it is. It's the same
Okay.
thing.
Okay.
Yeah. So a conservator would be, I guess, to be more specific, conservator generally is guardian of the estate most of the time. Not necessarily guardian of the person, but it's the same category of being someone's guardian, if that makes sense. With power of attorney, the question again is, does the person have capacity? If they have capacity, and I don't mean that like an 18-year-old needs to know everything about life, because that's just not realistic. You know, I'm 36 and every day is a new opportunity to learn about life. I don't know about you too, but that's, you know, there you go. So with power of attorney though, are you able to enter into a discussion about your assets? Are you able to enter into a discussion about making your own healthcare decisions to the best of your ability? And we see what that looks like depending on the person, because it's different compared to, you know, different people are different. And it takes time. You know, I had a lady in my office a couple weeks ago who has cerebral palsy and very opinionated, which is great. Very anti-guardianship, because she can speak her mind and she will tell you. It may take her 20 minutes to deliver that, which is fine, you know, but guardianship's not appropriate. So really, whether you retain your rights under a power of attorney and you nominate somebody to help you in a power of attorney, which is helpful too, depending on the circumstance, or whether you're not able to have capacity and have these discussions, guardianship may be a better fit. Now let's twist, and I'm going to add something you might not have seen coming. Sometimes because, you know, why not, right? Let's make this a comprehensive picture. Sometimes somebody might need help with healthcare decisions, but is totally fine making financial decisions. You can actually have a financial power of attorney and a guardianship over the person. You can have both. So it's not as though you have to, So it's not as though, you know, oh my gosh, if you have a guardianship over the person, you're not allowed to have a power of attorney over finances. You can have both. Now, that's not always appropriate. You know, if the person can't speak their mind and, you know, doesn't have capacity, maybe that doesn't work, but maybe it does, depending on, you know, the set of facts.
So then is it easier to kind of lose the power of attorney? Because I know you said guardian, getting out of it is difficult.
So, you know, there's this thing called the internet that people pull documents off of. I'm not a big fan of that, to be totally honest, and not just because I'm an attorney and I don't get my medical advice off of Google, you know, I'm just saying, but it's just better when you work with somebody who knows what they're doing, especially and it's such an important set of, you know, topics here. So that's my disclaimer, cynical bit right there. But you just need to meet with an attorney and have your documents updated, essentially. Or revoked altogether. Like, meaning I fire you, whoever. But, you know, it's always funny, I guess, when I have a set of parents come in with a kid who turns 18, you know, and I'm like, well, you could fire your mom and dad. I probably wouldn't recommend it,
Yeah.
but
So this is not on the list, because so what I'm hearing from you, which is so important, is being able to kind of represent both the parent and or guardian type person in their life, and also the individual. And I wonder if every attorney is like that, because I hear you with, I mean, is this standard for guardianship, or because I'm hearing something from you that stereotypically I would feel like I didn't hear from every attorney. Is it because you specialize in this, or I don't even know if my question's clear.
So taking into account both sides of it, is that common? Maybe?
Yeah.
Is that the question?
Yeah.
So it should be.
Okay.
It is, and I have a lot of colleagues and a lot of mentors. I am not the only one that does this work, and I am not here with you professing to be an expert. You know,
Right,
I'm always
right.
learning.
Yeah.
And you know, it's interesting, this natural analogy, I guess. This past weekend, I was in Chicago doing some yoga stuff. And anyway, the yoga place I was up at in Chicago, they call it a yoga school and not a yoga studio. Not that there's anything wrong with either, but they call it a yoga school. And when I was up there the first time, I was like, I don't understand. Like, is there going to be a test, or like, I don't get why you call it a yoga school. And the owner of the school, who I'm really good friends with, was like, well, I'm still learning too.
Yeah.
You know, so I try to take it from the stand. I try to take my yoga practice and my law practice in the same vein of always learning something new.
Yeah.
And also, like, I have a brother who has special needs, who has autism, dyslexia, and Crohn's disease. So for me, and I know for a lot of my colleagues and mentors who I'm very close with, we do take it personally. As far as trying to advise to the best of our ability. Is that always the case? No. Right. I've had a mentor draft a new set of powers of attorney over a phone conversation. I don't do that. I insist on meeting the person in person or via Zoom these days if we have to, you know, it just depends. But there are people that don't do it with as much sensitivity and cautiousness, I guess, as I do, and a lot of my mentors do as well.
And sorry, Megan, I know this is what I imagine. Panicked parents calling up, trying to just get that done because they're so panicked that if they don't get guardianship, it's going to be a catastrophe for their child. So to hear you talk about this, it's actually super refreshing. And I wish that schools, and I know we all put a lot of stuff on schools, but I wish that this conversation could occur for parents before even 17 and a half. Like when you get in high school, you start hearing some of this stuff and some of this information so they can find a professional who has a balanced approach. So that's just me chirping in on my opinion, because Megan and I talk about this all the time. You're trying to get things done. You're in crisis a lot, especially with individuals with certain types of behavior. And you want to get it done because you're so afraid of what's going to happen if you don't get it done. So thank you for letting me listen to this. It's interesting.
It's all good. I do a lot of speaking, some more remotely, it would seem, because of COVID. To schools, and they allow myself and my dad, who's a certified financial planner, Gordon Holmes with Mass Mutual, speak on both sides, on the financial side and the legal side. And again, not to say he's the only financial advisor who does it either, but we go into schools and either Zoom or whatever support groups of all sorts, talking to parents. And we also go to different transition fairs. So last week it was Carmel at HSC, Hamilton Southeastern High School. A couple of weeks before that, it was in Danville. So we we're always looking and open to opportunities to speak to parents, support groups, schools. Schools candidly are also really good referral sources for me.
Mhm.
Because we've been having open dialogue with that. And to the extent that I can eliminate the stress, because we all have stress, I
Mhm.
mean, that's why I do yoga. Geez, you gotta stay sane somehow.
Yeah.
But to the extent that we can diffuse some of the stress out of that conversation on both the educator side and the
Yes.
students and the parent side, that all around it's better for everyone.
Yep. Yep. Thank you so much.
Mhm. Yeah, and schools do great things, even with their limited resources. So I will echo your sentiment on that. It's easy to blame somebody.
Mhm.
I pick Social Security, really.
Mhm.
But that's my opinion.
Yeah. That's so funny. Ah,
Not that Social Security isn't working hard either. It's just I seem to get different answers depending on who I talk to on the phone. That's all I'm saying.
no, wait. Okay. It's okay. Um,
So can you explain what is needed to get guardianship versus what's needed to get like power of attorney?
Sure. So there really isn't anything needed to get a set of power of attorney documents other than having a conversation and knowing who you want to serve in those roles. That's the time, and the conversation is what you need for a set of powers of attorney. And obviously it would be helpful, maybe not obvious, to have conversations with whoever you're naming a power of attorney, so it's not a shock if something happens. With a guardianship, you start off with a physician's report indicating what the incapacity is, and then there are some other documents we prepare for clients. There's something called a guardianship registry that the court requires, which is like an oversight of the guardianship. What if you die? What if your kid or whoever you're serving as guardian over dies? What if you change addresses? We need to transfer the guardianship. There can be all sorts of reasons why they need oversight. And then once the guardianship, we move forward through the process. And once the guardianship is established, then it depends on the court as to how often reports are due and what type of guardianship, of course, it is.
Okay.
Does that help, Megan?
Yeah.
Okay.
When I had applied for guardianship, like I worked with you, obviously.
Mhm.
And you had asked like what I do like for work and everything. Just because like the court, you didn't want the courts to think I was getting guardianship just for the benefits, which I understand. I mean, that can happen, unfortunately. A lot of the families that are in our support group, like we have the higher needs, the more aggressive, like they can't work. So how can they kind of convey that that's not the reason they're getting the guardianship?
Sure. So two of the qualifying questions of being a guardian, just to take a step back in a little bit to the left or right, whichever direction you want, I don't know. Do you have a felony, and have you been accused, investigated, or convicted of abuse or neglect of an adult or a child? So those are the two qualifying questions of being guardian. And then the other thing is, again, as you were saying, Megan, just making the point that you're not trying to financially gain off of whoever you're serving as guardian, because unfortunately I have had that happen,
Right.
where clients aren't listening to what I and the judge are saying, and then they lose guardianship, and that's the only reason why I can say I've lost a guardianship case, by the way. I'm just putting that out there. But anyway, the way I would handle that, because I have had clients who are retired, who aren't working and that kind of thing, is I might ask the question, do you have your own source of money? Are you sustaining? Do you have your own source of income? What does that look like? Do you work odd jobs? I have some parents who serve as care takers for their loved ones with special needs and get paid through Medicaid. Just making the point that there are monies out there aside from the $841 a month for Social Security, because you shouldn't be living on, no one should, that's not a lot of money in general, which I'll avoid that rant, but you as the client and the guardian should not be living on that money.
Right.
That's
I mean,
a
it's
challenge
for your kid. I mean, it should be used
Right.
for them. It should not be used for you.
Yeah, that is that's like an emotional topic too, right? Because what Megan said was, you know, quite a few parents cannot work
Mhm.
because of these behaviors. Schools won't take their kids. They
Mhm.
can't find, like, how do you cover yourself? I mean, my assumption is, and I agree with you, most parents are trying to do the best that they can.
Mhm.
You know, how does a parent, like, how do they document that? I mean, I know you said, okay, make sure you have your own source of income. What about if they're on Medicaid as well? The parent, is that possible? I don't even know if it's yes, it is possible.
It is
You
possible. They can be on Medicaid and they can be disabled themselves. And it just depends on the conversation. You
Right.
know, it's just different every situation. As far as how they make a wage and living, I think that goes beyond the scope of what I'm able to contribute today.
Oh yeah, no. Thank
you
you
know?
so much. Yes.
Mhm.
Yes,
It
I
just depends
appreciate
on the
that.
situation. You know, is it a 2-person household and one works and one stays home? You know, I mean,
Right.
it could be all sorts
Right.
of different things.
Sure.
Yeah.
Yeah.
Mhm.
What happens if one parent is out of the picture? How does someone go about getting guardianship?
Mhm. So if you think of the guardianship in thirds, you get the physician's report, you have the initial consultation, all of that, and then a petition is drafted. The petition, whether it's guardian of the person and estate, just person, just estate, regardless of what it is, a petition is drafted. It's an appearance, which is a document that just indicates who represents you in court, is prepared as well with the attorney's contact information, your contact information. It kind of operates as a shield because the court should be contacting your attorney and not you. So those are all the initial documents in general. And I'm not going to go into the weeds, but in general, those are the big picture documents. Then it's filed. In my experience, generally speaking, from date of filing, about 30 days out. Again, if it's super early, maybe a little further out, but is when the day of the hearing is. The day of the hearing generally happens on or after the 18th birthday. I personally will not go in until on or after the 18th birthday, because up until the 18th birthday, if it's a parent specifically, they're already the natural guardian, and I don't want them having to go to court twice because it expires on the 18th birthday. So you get the hearing date, make sure all is well, make sure it works for everybody. If dad or mom is not one of the co-guardians, notice has to be served on the parents, on the siblings, and if they're married, on the spouse. And if it's like grandparents want to be guardian over their grandkid, I take the cautious approach based on judges' recommendations that I've had before, where I notify all people on the same level. So if dad's parents want to be guardian, then I'll notify mom's parents at the same time, just to avoid drama.
Yeah.
So if mom or dad are not being co-guardian, then they're notified. We send notice, and then we send a consent that needs to be notarized. And I generally encourage clients, if at all possible, to have that conversation before we even file, to know whether it's contested, meaning people are fighting, meaning mom or dad who isn't a co-guardian isn't okay with that, and they hire an attorney, or maybe they don't hire an attorney and they make it a big mess. Right or wrong, just saying, like, it can get complicated if somebody's fighting, just so we have an idea ahead of time. And then and this has happened in a few cases now, if they don't know where mom or dad is, like they don't have a physical address, then the question I generally ask is, are they on the birth certificate? Because if they're on the birth certificate, then there's no way around it. We do have to send notice. And so the way that I've found to handle that situation is to publish notice in the newspaper, which is an additional expense to the client, but I don't really want to go to court twice if we can avoid it. And if we haven't notified a parent, I can guarantee you we're going to court twice.
Yeah.
It was interesting that you have to inform the siblings. Like, after you said it, I understood why, because you want to make sure, like, it's not like the parents, parents are kind of maybe not be the best person or whatever, but it's definitely different things to think about. What is the court date like? What exactly happens? And does your child have to be present?
So does the child have to be present? Depends on what the physician says in the physician's report. The one that I use most of the time, question 5, indicates whether they can appear in court without causing a harm to them, their health, or something like that along those lines. And so if the physician says that they can be there, they need to be there. Now, being there is kind of fun, that phrase. In different counties are different situations. You know, in Hamilton and Marion as of late, everything's been virtual. So Marion uses WebEx, Hamilton has been using Zoom, Boone County has been using Blue Jeans. Well, I've just learned all sorts of different programs. But then other counties, Hendricks County as an example, everything's been in person. I was just in Fayette County yesterday and everything's in person. Not to say that they wouldn't consider a motion to have things virtual, but there are some courts that are doing everything in person and not allowing, unless, you know, there's a real reason, you know, for them to be virtual. So then the hearing itself, it just, again, depends on the court, but in general, it's you know, you have a guardian ad litem if it's Marion County, who's a representative of the court, just making sure you're not tricking anyone in to be a guardian. Otherwise, in most of the counties I've been in, there's only a guardian ad litem if people are fighting, most of the time. So as far as what it looks like, I'm in there in person or via Zoom, WebEx, whatever, with the client, and I ask most of the questions. The judge sometimes has questions, depending on the county. It depends on how many guardianships they have. And so they may not be as familiar with Social Security benefits or special needs trusts or something like that if it comes up. So I answer questions along those lines. But primarily, I'm the one that asks the questions when I have those hearings. And then the judge, again, may have additional questions. And then at this, after the span of 20, 25 minutes, a guardianship could be granted. And I never guarantee what a judge would say, you know, I can't say 100% that the judge will grant it, but I'm pretty experienced in this. And I know what I say as of late is I would be surprised if this doesn't go through. That is, if no one is fighting. If somebody is fighting, that's a whole different realm of, I don't want to say entertainment, like I'm entertained by people's woes, but like, it's just a different adventure to go down.
Yeah. So you explained a little bit about what a court date looks like. This is how much does it cost for services generally for guardianship?
You know, it really depends on the attorney, and it depends on what type of guardianship and where. So I would really like to refrain from giving numbers.
It's okay. Yeah.
I will share, I do free consultations to start the conversation and figure out what the scope of work is, which that seems to be an anomaly too, as of late, I guess. I've had a few clients recently go, there's no fee for today. No, I mean, I don't allow the consultation to go on forever, you know?
Right.
But you know, no, we talk about the concern and maybe, you know, maybe we move forward with guardianship, maybe we don't. It just depends on what the situation is at the time.
Yeah. During that process, and forgive me if I'm not trying to get a number from you, I promise.
No, you're fine.
Two things. Do you accept payments from clients? Can they, like, if it's a certain cost, can you do payments?
I generally do payment plans on almost everything I do. Yes.
Perfect. Okay. And then after your consultation, are you able to kind of give a guesstimate on?
Yes.
Okay. Okay. So they're not going into everything blind. Okay.
No.
Perfect. That's wonderful. Thank you so much. Yep.
Yeah. And that seems to be not a common thing either with regard to the payment plans. You know, so yeah, that is something that I do. I get that people have expenses, you know, other than needing legal services. So to the extent that I can make it affordable, I try to do so. Yeah, but at the end of the consultation, I do give them a fee. If I know the scope of work, you know, a quote, and then I allow payment plans, and I generally don't charge interest on those payment plans as long as they don't fall off the face of the earth.
Wow.
If they do, then we have to have that discussion, which that's, you know, the negative, I guess, of being in business. You know, I have to make a living. So
Yes.
we have that conversation, but overall, I try to be as flexible as I can.
That's awesome.
Mhm.
Do you work with families who have loved ones in residential homes?
I do.
Does that make it harder to get guardianship?
You know, it depends on which county.
Wow.
To be totally transparent. The guardian ad litem in Marion County has added an extra wrinkle in notice requirements for guardianship hearings. He wants an affidavit from somebody at the facility saying that they've served notice on the person. So the statute just says US first class mail is what's required, but he has added an additional wrinkle. And because of his position in the court, he's allowed to, you know, kind of like Social Security or Medicaid, you kind of give them what they want, even if it may not be technically required at times. So if you don't have somebody willing to sign an affidavit, you know, saying that they served notice, then it can be a little more challenging. I personally am not going into facilities right now. Not to say I will never, but with my brother being immunocompromised with having Crohn's disease, I try when I can to be careful and avoid that. So there have been situations where, for instance, wanting an affidavit notarized, if they don't have a notary on present, you know, on site, then we have to do it without a notary and pray that that's okay with the judge, because there is no notary and I'm not going in. So
Right, right.
Mhm.
Can a foster family get guardianship?
Anyone can file for guardianship over anyone would be the answer.
Okay.
Mhm. It would be nice if they have a connection, you
Yeah.
know, like not
Mhm.
just somebody random off the street, but the reality is anybody can file.
Okay. Wow.
Mhm.
We kind of touched on this. What if the parents are separated and both want guardianship? How difficult can that be to resolve?
Mhm.
How does it get resolved? And does that bring about extra costs?
So the answer to that is it depends. If they're able to get along well enough to serve together, then perhaps working with myself or another colleague, you know, one attorney is doable. If they're not, because no attorney should be representing two people that can't get along, that just it's not very productive of anyone's time. So in that situation, if I've met with a mom, say, or a dad, and the other person is hostile and not cooperative, et cetera, I might suggest that they get their own attorney. You know, the other way I've had it is I represent one of the parents. Just to list parents, I represent other people than parents, but just as an example. So I represent mom, let's say, and dad is kind of a passive participant in the guardianship. And so I'll draft the paperwork for mom representing mom, but not dad, or vice versa, representing dad and not mom. It just depends on the situation. As far as how it gets resolved, you know, I've had situations where mom and dad have gone against one another, and if they can't agree and they can't figure it out, the judge figures it out for you.
Right.
So
Mhm.
I don't know that that's ultimately when they're disagreeing with one another. I don't know that they're I don't want to judge and presume to know what they're thinking, but I have to wonder whether their child with special needs is actually the number one priority if they're focused on hating one another. I'm just putting that question out there because when I've seen it, and I'm sure other attorneys can attest to this, and parents who have been through it, even when people are going at it and are not getting along, they're racking up more legal fees. Not that it's all about money, but I mean, if it takes more time, it's going to cost more money. And at the end of the day, if you let the judge decide who has your kid, then that's why we have courts, you know, that's why we have litigators who fight over on behalf of their client, all sorts of things.
Yeah. Yeah.
It's a bit of a like depressing note, but that's the reality.
Right, right. Are there other things that bring about extra costs regarding guardianship?
Publishing notice in the newspaper, sending certified mail. If somebody's going to dodge notice, for instance, sending certified mail for somebody to sign. if you move counties, not to say it has to happen right away, but transferring the guardianship might provide for extra costs. If you have a second attorney in the mix, obviously that will cost more. If the physician isn't comfortable filling out the physician's report, which I'm going to avoid that rant too, and you need like a psychologist report to make them feel more comfortable, so a more thorough analysis, say, then that might cost more. I've had some physicians charge to fill out the physician's report, few and far between, but I have had that. So yeah, those are all of the ones I can think of. Not to say that's a limited list, like, or,
Right.
but yeah, that's all I can think of at the moment.
Thank you.
Mhm.
Is guardianship something you do and it's done, or is there like maintenance that needs to be done over time?
There is maintenance that needs to be done. So depending on the type of guardianship, if it's the estate and inventory, accountings need to be done based on whatever you're managing as guardian. If it's just guardian of the person, which again, when you have a child turning 18 that has special needs, that's more often than not the type of guardianship we get. For the parent, then it depends on the court as to how often. Most will do it every 2 years. And I stay on the guardianship case with the client. We're not always perfect at reaching out based on when their reports are due. And thankfully there's grace that goes both ways on that. But with regard to how often, it just depends. I know in Hamilton County, there's a report due the first year and then every 2 years thereafter. In Marion County and in most counties, it's every 2 years. In Morgan County, it seems to be every year. And Putnam's the same way. So it just depends on, the court. Some courts have waived it, which I don't necessarily agree, because I feel a status check on whether the guardianship is needed, and it's a 1 or 2 page document, isn't that much to ask for, but
Right,
it just
right.
depends on the judge and the court.
Yeah,
Mhm.
that's it. I was just going to ask you, what are they looking for? But you just answered it. You know, they're
Mhm.
looking for just status check.
Mhm.
Seeing
Are
if
you
it's
still living
needed.
in the same house? Is the guardianship still needed? Are you all still alive? Maybe the
Yeah.
guardianship isn't needed.
Yeah.
Maybe it isn't, maybe
Mhm.
things have changed.
Yeah.
We just had a couple questions that we kind of just thought of right
Sure.
before this.
Yeah.
Is there ever a time when getting guardianship is not a good idea?
Every situation's different. So yes, there are situations where getting guardianship probably isn't the best idea. And unfortunately, when I say that and when I think it, I'm more speaking about protecting the parent than I am the person with special needs. So there are times, unfortunately, when behaviors, and I don't necessarily like that word either, because we all have behaviors, whatever. It's like out in the community.
Right.
Like we all go out in the community. I don't know why, because you have disabilities, that's a phrase. But anyway, with the behaviors of, I had a guardianship where a couple of parents adopted a child who had a juvenile history of difficultness. And he proceeded to make a lot of bad decisions. They co-signed an apartment because he can't enter into a contract because he was under a guardianship. He got evicted from the apartment, and that's not only on his record, that's on his mom's record as well, who co-signed it. He got a few women pregnant and has kids and has child support, even though he has no money due. And so he tried to get married under a guardianship, even while under a guardianship. And while you would think it would be enough, and I did at the time think that it would be enough to, oh, you're under guardianship, that'll just cancel this out. That wasn't that easy. They had to go to court and get it annulled and determine whether he had the capacity to make the decision of getting married. And if he did, maybe the guardianship wasn't needed anymore, which the client at the time really wanted to be out of the guardianship anyway. Didn't want to be guardian over their kid anyway, because it had kind of turned into a nightmare. So it was kind of a blessing for them. Ultimately, he wasn't ruled to have capacity, so it was canceled. So that wasn't helpful. But the only way to address a situation like that, as far as get out, is if the capacity has been regained or if they found another guardian. And unfortunately, with this set of facts and this particular client, we couldn't find another guardian who, after you explain why you don't want to be guardian anymore, I can't really see somebody wanting to sign up for the challenges. So when I have somebody who has a lot of hostile behavior, I don't always recommend guardianship because of the heartache and the headache. It would be not just on the person with special needs, who obviously would be first, but also the parents, or whoever's looking to serve. I mean, my very first guardianship, I'll never forget it. So excited. I was like, oh my gosh, I get to be your lawyer. This is so great. Was an older gentleman who wanted to be guardian over his brother who lived in a facility. And he had to be in his, I would guess, 70s or so. That might not be right, but he was older. Anyway, the facility called him at 3 a.m. a few different times because his brother had dementia and wasn't doing well. And he was like, I'm out. I'm done. Like, I don't want calls at 3 a.m. So it depends on, and there were ways to fix that had he asked before he decided he was done.
Right.
But, there's all sorts of different circumstances as to why you should pause before just proceeding.
Pause.
Mm-hmm.
That's a good phrase. Pause. Or word.
Mm-hmm.
Pause for a moment. Don't panic. Pause.
Mm-hmm. Yeah.
Yeah.
Mm-hmm.
Yes.
Or use that free consultation.
Use some free consultation.
Yeah, via Zoom or in person or phone. Mm-hmm.
Yes. Wow.
Power of attorney and estate planning, to be clear, is only Zoom or in person. I will not do it on the phone unless I've met with you before. And that's just to make sure you know what you're talking about, basically. Yep. With regard to your wishes. If you think you're in the state of New York and we're in Indiana, for instance, that would be a problem.
Yeah.
And then the last question we had was in regards to future planning. Like our group has, like I said, the loved ones that have the higher behaviors, the higher needs, everything like that. What if, like, you're guardian, but you don't have someone that's willing to step up when you're not there? Like, what happens, or what can you do?
So there are different programs around the state called VASIA programs, volunteer advocacy programs that can serve when there isn't anyone, and often they're appointed by the court. So that's one piece. The other piece could be that you have friends that might be willing to step in, maybe not, but that's an idea. Family, if possible. I know it's not always possible depending on the circumstance, or maybe they have 3 kids of their own and then that's really not, feasible. So there's that. And then I have a very limited amount of friends who serve as professional guardians. That's what they do. They get paid for, the service they provide, but at this moment, those would be the options.
Is that something you set up? Like, I mean, like, you kind of want everything set up before you die, obviously.
Absolutely, yes. So in a will, that's where you would address who after you, not in the moment. So, and that comes up a lot actually as of late in guardianship orders. Clients will say, oh, can't we list who the backup is in the guardianship order? And the answer is no, because until they're actually appointed, they don't have any authority to serve as guardian. So there is a document called a standby guardian, which allows you to nominate somebody in the gap, in between when you can't and they're appointed, but ultimately they don't have authority to serve until they're appointed.
Okay.
Wow.
But in a will, and that's, Megan, I'm glad you asked that. So in a will, it'll say, in the event upon my death, my spouse does not survive me, and any of my children have not attained the age of 18 or have attained the age of 18, then it is my desire that the court having jurisdiction appoint X as guardian. You're not actually appointing anybody in your will. You're nominating them for the judge to consider it. Because what if in between now and whenever we die, whatever date that is, they get a felony, then they probably shouldn't be serving as guardian over your kid.
Right.
Okay.
And that's a broad statement. we're working on, we're having discussions, I should say, in the state bar of fixing that. And I say fixing it because what if you run out of people and the only family member left has a felony and it was
Right.
from 10 years ago and they weren't able to expunge it? Like that is a real
Right.
concern that we're working on. We're digging deeper into, but at the moment, that's how it is
Yeah.
with regard to the law.
All right. Well, I think that's all we had. Denise, did you have any other questions?
I don't, but I'm just wanted to say thank you for your time and your passion. And I mean, just kind of gives me hope that there's really good people out there that kind of can help others be guided through this process. So I'm just really grateful to have this interview. I appreciate it.
Well, I appreciate you guys and what you do because I certainly cannot do it by myself. So
Thank you.
thank you for your time.
Thank you.
You're welcome.